Hi, everybody. Welcome to the Elder Law series. Just give me one moment. I know we're running just a couple minutes behind. Thank you so much for your patience. I'm just going to pull up, share a little PowerPoint really quick, and we'll get started. So we are here today for the virtual elder law series, and today we're talking about planning ahead and legal and healthcare essentials for peace of mind. Our presenter today is attorney Emily Lawson Hatch with the law firm Bousquet Holstein. So my name is Sam Agwam. I work with Volunteer Lawyers Project VLP that is hosting today's virtual series. We've had a three-part series so far. Our Volunteer Lawyers Project organization, we provide free legal information, assistance, and representation for low-income individuals in general in the Central New York area primarily. We're a non-for-profit legal aid organization. We do our work because of our dedicated staff and our wonderful volunteers, including attorneys like today's presenter, paralegals, other professionals, and law students all support our work. As a reminder, we had a couple other sessions earlier this month. We had the guardianship presentation, senior scams, and today we're doing planning ahead. Uh, as you might recall, if you were able to join us, and if you weren't, it's okay because we did record all those sessions. They're already available on the VLP website, and it's the same website you went to register for today's event. So if you have any friends or family that weren't able to attend but wanted to learn that information, they can go there. And if you have to jump out today early, you can always come back and revisit today's presentation by Emily. So, with welcoming our speaker, Emily Lawson Hatch, today, Emily at Bousquet, her practice focuses on estate planning, trust, elder law, estate and gift taxes. She helps people plan for aging, long-term care, medical decisions, personal wishes. She is an author of the Syracuse Law Reviews, Trusted Estate Survey on New York law. She's a frequent guest speaker for community groups, churches, companies, professional organizations, and a long time, and this is probably the most important thing, long time volunteer of the Volunteer Lawyers Project and a friend to our organization, countless hours volunteering for our clients, and has really been a mentor for our staff, including myself and other volunteers. So we are super grateful to have her here today to share her knowledge on planning for the future. So with that, I'm going to stop sharing my screen and I'm going to let Emily take it away. Thanks, Emily.
Thank you, Sam. I'm happy to be here today talking about something I love. So the documents I'm going to talk about today, many of you know what these are. You've heard of them before, but I'm going to try to give you a real good basic understanding, and hopefully you can leave today with some fun facts and information that's helpful to you and helpful to people that you know. So when estate planning attorneys like me get involved with a client, oftentimes I'll hear from a client, well, I don't have an estate. I don't have a big fancy house on a hill and an estate to deal with. But and that may be true. I don't either. But we all have something. We have a bank account. We've got stuff. We have our personal possessions. We might own a home. We might not. Whatever you have is your estate, and it is important, and it's what you work for. And so oftentimes people want to make sure that those assets get settled after they pass away. And the way you do that is by planning ahead. So as an attorney, what I recommend is that every adult have 4 documents. And I'm going to review those with you today. And then there's also other documents too that may fit your situation. So the first document we always think of is a last will and testament. A last will and testament is a document that you use. It's specific to the state you're living in. So if you're in New York State, you'd have a New York State last will and testament. And in your will, you're making some choices. You're deciding who's going to be in charge of my stuff after I'm gone. That person is going to be called your executor. And you'll put a first person as your executor, and you put a backup and even another backup after that. You could have executors that are called co-executors, 2 people that work together. You can even have 2 or 3 people. Generally, attorneys don't recommend that because it is hard oftentimes to work with somebody else in a big role like that. But you can choose co-executors, but generally we're recommending a first, a second, and a third so that you've got backups and your will lasts you a longer time. So if somebody so maybe I name my spouse, but by the time I'm gone, maybe my spouse is gone too. And maybe I want to name a sibling. And then maybe I want to name someone of a younger generation so that, again, there's somebody there. If you have a will and all the executors have passed away, then your next of kin has authority to petition the court to become your administrator for your estate. So it is awfully nice if you can pick who that person is rather than leaving it to your family and friends to make those decisions. So in your will, you're deciding who's in charge. Maybe you're also going to name some other people too. If you've got minor children, which is children under 18 years of age in New York, you're going to need to name a guardian for them. And again, you want to at least appoint a first person and a second person. You can name a third if you want to. So now you're thinking about who's going to be in charge of my estate, who's going to be in charge of any minor children that I have. And you might even be naming trusts in your will, and then you're appointing someone who's the trustee. And we'll talk about that a little bit more. So in your will, you're saying who's going to be in charge, and you're also saying who's going to get my money and my stuff. There's different ways in a will that you can say who's getting your money. So you can say, we're first thinking specific. Is there anything specifically that I own that I want to go to someone? Like, I want my car to go to Joe, or do I want my jewelry to go to my daughter? Or anything specific for a specific person. You can even say, I leave my Empower Credit Union account to, my sister. You can say specific items for specific people. That's the first question we're asking. Is there anything you want to go to a specific person? Beyond that, there's two big piles of assets. The first pile are your personal effects. It's your couch, your dishes. It also includes vehicles, but it's your tangible personal stuff. And who do you want that to go to? So you make the decision. You can say, I leave it among a group of my family and friends for them to distribute as they see fit. You can leave it all to one person. You can leave it all to charity. We often have language in there that says, that gives your executor some discretion. Because if it's personal effects, you can understand that sometimes you might have things that are going to be donated or sold or even disposed of in trash. And so we leave the executor quite a bit of discretion in there as to how to handle that personal property. Then beyond anything specific going out, beyond any personal property, then you're deciding who gets everything else, who gets the rest. And the rest, we call that your residuary estate. It's everything left, all the rest of your bank accounts, any other real property, home, vacant land, things like that. Who's going to get that? Usually those assets would be liquidated, but they don't have to be. You can decide, I want my vacant land on the corner to go to my brother. You can say that, or you can say, I asked my executor to sell the land and then give my brother the net proceeds, the money from it. Ultimately, you get to decide, but we put all that information in your will. Now, will in New York State has to be signed appropriately. And in New York State, what that means is you have to sign your will at the end of the will. That means if you sign on the last page and then you write a bunch of information after your signature, it's not going to count. Your signature is the last part of your will. So you sign at the end, and New York State requires 2 witnesses to witness your signature. The witnesses shouldn't be people who are mentioned in the will, but it doesn't have to be anyone special. It has to be someone who's over 18 and who is witnessing your signature, and they have to write their name and their address on there. And so that's your will. Who's getting what, who's in charge, and you want to make sure you sign it properly. The second of the 4 documents you want everyone to have is a power of attorney, usually referred to as a durable general power of attorney. That's the kind that we're looking for. A power of attorney is a document where you can name someone else to help you with your finances. I myself have a power of attorney, and my husband has a power of attorney, and we even use those frequently. So for example, like when we bought a house or we've refinanced our house, if he can't come to the closing, then I will sign for me, I'll sign for Emily, and then I'll use his power of attorney because he's named me in his document, and I'll sign for him too as his agent. When you're the power of attorney for someone, so in this form, the New York State form, you're naming a first person and then a second and a third, just like your executors of your will. And again, you can name 2 people together, but we usually recommend you not do that. It depends on your circumstances. But you name your agents, and then your agents sign the form too to accept the duty to help you in the future. It used to be that powers of attorney were called springing, they were called springing powers of attorney. And they sprung into effect when the person who signed it was incompetent or unable to manage their finances. And it used to be that two medical professionals had to sign off and say, okay, well, now Emily isn't able to manage her finances anymore. And then a power of attorney, my agent, could step in to help. It became really onerous for people to be able to do that. And so they took away that requirement, because you can imagine doctor's offices would get called in as witnesses. They'd say, you know, you allowed this person to act as power of attorney because you declared that someone was incompetent or unable to handle their financial affairs. And then the doctors or nurses would get called in to testify, and they got sick of doing that. And so they changed the law so that now powers of attorney are good as soon as you sign them. It's not waiting for you to become incapacitated. So that's why my spouse and I get to use them at house closings, because he can be fully competent and I can still help with his financial affairs, and vice versa. If you're the kind of person who doesn't want that and wants the power of attorney to only be used in certain circumstances, we can add language to the form. So we could say, typically under powers of attorney, they're used right away, but we can say, you know, for Emily, this power of attorney only goes into effect when one physician signs off on incapacity. Maybe I want it to say something like, my power of attorney only comes into effect when all of my children agree that I need help with my finances. But I can put in a contingency if I want. That power of attorney document is really, really important, because it's helping to take care of you when we care about you the most, which is when you're alive. Not after you're gone and your will is being used, but we want people to be able to help you now. So we've got that power of attorney. The third documents, we talked about wills, talked about power of attorney for finance. When you also, I just want you to know, when you pass away, your power of attorney dies with you. So the agent of your power of attorney no longer has any legal authority after you've died. It's then your executor of your will would step forward, and now they would have authority over your assets. Maybe it's the same person and maybe it doesn't matter so much, but it is important to know that the power of attorney dies with you, and it's your executor that would handle things from then out. So the third document after the will and power of attorney, the third document is a healthcare proxy. A healthcare proxy is the document where you're doing two things usually. You're naming an agent that can make medical decisions for you only when you are incapacitated and can no longer make your own medical decisions. And also you're waiving HIPAA in that form. So you're naming agents, a first, a second, and a third, and then you're waiving HIPAA. In the healthcare proxy, you can't appoint co-agents. The law only wants you to appoint one at a time. And that's so when you're at the hospital or in a healthcare situation, those healthcare professionals can go to one point person to get their questions answered. In the healthcare document, you can put in additional language that says what your wishes are. At our office, we usually have those in two separate documents. So the healthcare proxy, where you appoint a person and you waive HIPAA. And then we have a separate document. It's called a living will. Your living will is where you're saying what your end of life wishes are. Maybe they're going to say that if I'm at the end of my life, I want extraordinary measures used to keep me alive. I want the best chance of life possible. The more likely scenario and the living will we use the most is the kind that says you do not want extraordinary measures at the end of your life. But ultimately you get to decide what you want in that document. So our living will follows the hospice method. And if you enter into hospice, you're saying, I agree that I'm dying now and I am foregoing most treatment. You can be kept comfortable, pain medication, but you're usually giving up dialysis and giving up some of the treatments you've been using to keep you alive. So our living will says, at the end of my life, I understand that death is a natural part of life. And I asked my agent that if I'm in a situation where they don't think I have a meaningful chance at life, at quality of life, that they can let me go. So I sort of think of the living will as the document that says, I give you permission to let me go. I've already thought about this ahead of time. You don't need to have any anguish about it. You can let me go and know that this is what I would have wanted. So those are the four primary documents. And then there's some additional documents that sometimes people want. So the one additional document I see quite often is called an appointment of agent to control your funeral and burial. So an appointment of agent to handle your funeral. And so sometimes people, they'll say, you know, I've got all these family members and I want one person to be in charge. Maybe that's because they want to be cremated and they feel like their family members would struggle with that. Maybe they want to have a certain kind of religious service, or they don't want that. And so they want to appoint someone who would be in charge and make sure their wishes would be fulfilled. On that appointment of agent document, someone's appointing an agent. And again, we always want to have backup agents. We want to have successor agents. You can even write in there what your wishes are. You know, I want to be cremated, or I want a green burial, or I want to have a, you know, a full Catholic mass. You can also say, I don't care. I don't care what somebody does with me, but I just want, you know, my sister Susan to be in charge of it and make sure it all happens. You can say in there, you know, I want my family to have a party. So that's where you can say any details and you appoint someone that can carry forward in those details. I've even had clients pick out their own hymns and really, really organize, but that's not a requirement. Some people like to do that. Any planning you do theoretically is supposed to make things easier on the people left behind. And so I want to talk about that primarily right now, is what are things that you can do to make it easier on other people after you're gone. Number one is getting those 4 documents in place: will, power of attorney, healthcare proxy, and living will. That's like the most basic thing that you can do to get people prepared and put people in charge so that they can handle things when you're gone. There's a couple other tools too, though, that I want to talk about. So those are deeds and trusts. So we're in New York State, and what's really cool is that New York State passed a law last year which allowed a new deed to be available in New York. It's called a transfer on death deed. It's a revocable deed, meaning you can change it anytime you want. And that deed, the transfer on death deed, is where you can name one or more people as future beneficiaries of your home. So if I'm Emily and I've got my home and I've got 2 kids, if they're over 18, I can add them right onto this deed, right over at the county clerk's office. I can add them onto the deed, and then when I pass away, they automatically are the owners of the home. They don't need to get a new deed. They are the owners. What's beautiful about that is it saves them time and money in the long run, because it's more expensive to transfer the property after you're gone, after someone's deceased, because you have to go through court and handle it. This means they get the property directly outside of court. It means if I owe a mortgage and things on the property, all that still has to get paid, but now they're the owners and they will figure it out and sort it out. So those are a beautiful kind of deed and a really cool way for someone to transfer their property for the future. Also, the great thing about that deed is you don't have to tell the beneficiaries right now. They'll find out later on. With every other kind of deed we have, you have to tell the beneficiary that they're getting added to the property, and they have to sign tax documents accepting that for the future. And you might think, well, why wouldn't you want to tell someone that they're on the property? Well, all kinds of reasons, right? Maybe you just want to keep it private. Maybe you think if they know they're on the property, they might treat you a little differently. Either way, you can tell them or not tell them. The other kind of deed that we see that's used a lot, so we've got the transfer on death deed. That's the new one. You get to name people as beneficiaries and then forget about it. And you can change it anytime you want, all on your own or with an attorney helping you. The other kind of deed we talk about a lot is called a life estate deed. A life estate deed. A life estate deed is the kind of deed where you can also add a beneficiary onto your home, and they'll inherit it when you die, but you're reserving something called life use in the home. This is the kind of deed where if you want to protect your assets, if you're worried about going into a nursing home, that's the kind of deed you would use for this, because with this deed, if you transfer the house or the property 5 years before you would need nursing home care or Medicaid, you can protect most of that property. That's a really beautiful kind of deed too. You don't get any protection with the transfer on death deed because you haven't really given anything away until you die. With the life estate deed right here, right now. So if I have my 2 kids and I'm using a life estate deed, then I'm adding them on to the deed. I'm saying I'm transferring my property to my 2 kids and I am reserving a life estate in it. That means I'm retaining the life use to live in my property. No one can kick me out of my house. No one can sell it without my permission. I'm gonna retain that, and it's a value. And a crude way to think about it is like, what does it cost for me to rent my house for the rest of my life? That's not what the calculation is, but that's sort of the way to think about it. And then the remainder of my house, and with the life estate deed, I'm giving it away to my two kids now. They can't do anything with it until I'm gone, really. But I'm, with a life estate deed, I'm giving something away. And so for Medicaid purposes, if you go into a nursing home and you already gave away the future of interest in your property with a life estate deed 5 years or more before you need Medicaid, then that future money you gave away, that future interest in the home is protected. And Medicaid can't force you to sell the house to pay for your care, and they can't put a lien on it. The only amount they can get to is that life estate value you kept, which is usually a very small value. So those are the two deeds that we see a lot. Sometimes people get their will and their basic documents done, and then they'll also use a deed in conjunction with it. That's a really nice way to plan. The other document that we're seeing a lot are trusts. There's all kinds of different trusts, but we see those all the time. And you know why? It's because there's an uptick in scams and online scams. When we pass away, if I'm Emily and I have a will, my last will and testament says I give everything to my spouse and then to my kids. If I have assets in my name that my spouse needs to get, then he would file my will with the court and ask the court to name him as the executor, and then he would get that money and get those assets, my bank accounts and my other things. Well, if he does that through the court system, through my will, it's all public. And that means anyone can search the court system. You don't even need a username and password. You can go right to the surrogates court. That's the court that we're dealing with after someone passes away in New York. The surrogates court is the court that manages estates and trusts. Anything that passes through there is public, so anyone can see it. So theoretically, people would be able to see my spouse's name and address. They would see how much money he got from my estate. And so we see a lot of scammers that are then tracking those things and trying to target the beneficiaries. And I'm not trying to panic anyone, because there's no need to panic. There's scammers doing all kinds of things. But this is a situation where you can say, I want to avoid that court system and I don't want to go through that. And you do that usually by having a trust or just making sure all of your assets avoid going through court. So trusts, the way to think of a trust is it's like you, but an alter ego, and it's a document. And it's a document. So if I have a trust document, it's going to say, I, Emily, am appointing myself as trustee of my own trust, and I'm putting my house in this trust. I just do a new deed at my office, and I might even name my trust, list my trust as the beneficiary of my bank accounts and other things, so that everything flows through my trust when I die. And then instead of having an executor, I'll say, okay, I'm trustee while I'm alive, but then I can appoint Joe or Sally as successor trustee. And then when I die, they can handle things. Another way to think about this is, and just so you know, if you have a trust, you still need a will, just in case I didn't get everything into my trust. My will would simply be called a pour over will, and it would say, anything I didn't get into my trust during my life, I hereby pour into my trust after my death. So if you have a trust, you still need a will. But I see more and more people trying to avoid the court process. And the court wants you to avoid their process too, if you can make other arrangements. So the other thing I want to say about trusts is, because there's such a variety of them, some trusts are used only to avoid court. That's all it is to avoid the court process. Because a will is a unilateral contract that only one person signs, me. So if it's Emily's will, I sign my will, but in order for it to be executed upon and work, there has to be a judge on the other end that has to accept it for probate. And probate just is a fancy term that means to prove. And so that's the court process to prove that a will is true and real, and that's a valid last will and testament. And once let's say my spouse submits my will to probate, the court, if the court accepts that will, then they have said, this has been proven to be an original last will and testament, and we've accepted it for the probate process. And So if they accept it, then my spouse works through the court system to handle my estate. With the trust, a trust is a bilateral contract. It's signed by the person who creates it. So the will is just one person, but a trust is signed by the person who creates it and the trustee. And so for the trust, it's basically a contract to avoid going through the court process. So sometimes people call us and they say, I went through court with my mom or dad. I don't want to have to go through that. I don't want my kids to go through that with me. And so we'll create a trust for these people. If it's a married couple, sometimes they each have their own trust. They sign their trust and then their family is going to avoid the court process, or at least that's the goal when they pass away. Another kind of trust, there's trusts that are sometimes used to protect assets from estate taxes. So if you've got a real large estate, and usually that means over $7 million. I mean, $1 million, I consider a lot of money, that's large, but it's not going to be subject to estate taxes unless you're over about 7 million in New York State. And if it's over 7 million, sometimes people use trusts to delay or defer estate taxes. And then the other kind of trust we use a lot is called a Medicaid Asset Protection Trust. It's considered an irrevocable trust, meaning after you sign it, you're not supposed to change it. And so if I'm setting up an irrevocable trust, it's probably because I'm trying to protect my assets from creditors. Maybe I'm worried about going into a nursing home someday, or maybe I have a job where I get sued a lot. Maybe I work at a hospital and I get sued a lot, and I want to make sure my assets are not in my name, because if I get sued, people can get to the things in my name. So sometimes people set up a trust and then they'll move their house or move assets into a trust so that it's not in Emily's name. So if Emily gets sued, people can only get to the things Emily can touch. But if it's in a trust and someone else is the trustee, then it's protected and it can be separate from me. Oftentimes, when we're dealing with these Medicaid asset protection trusts, it's because someone doesn't want their home to be sold or have to be leveraged if they go into a nursing home. These trusts are very effective, very helpful. But we kind of go back to the basic documents. I got a question here, and ask any questions through as I see this. So do you have to notify the mortgage holder on the transfer on death deed? No. Great question. So the question is, do you have to notify the mortgage holder on a transfer on death deed? For a transfer on death deed, you don't have to notify anyone, but for a life estate deed or any other deed, you do have to notify the mortgage holder. I've only been practicing 16 years. I've never had a mortgage holder say no, that we don't want you to do this transfer, because these transfers, either to a trust or to a family member, they're considered inter-family transfers. You're still staying on there as an owner. You're still responsible for the mortgage. So that's why the mortgage holder allows these, because you're still responsible until the date you die. And then they know that after you're gone, your estate or someone else will become responsible. So you don't have to notify the mortgage holder for a transfer on death deed, because you're not really transferring anything until you die. But for any other kind of deed, you do need to let the mortgage holder know. Let's see. And if there are any other questions, feel free. Okay. So these are all the documents. Let me talk to you a little bit about how to get these done. So when people are trying to get estate planning documents done, what's really cool is you can work with a lawyer if you want to. So I'm here, I'm a lawyer. There's lots of lawyers that handle this work. They're usually called trust and estates attorneys or estate planning attorneys. And we help people with wills, and we also help people handle things after someone has died. And we help the executor figure out what the assets are, go through the court system, or we'll help with the trust administration on the back end. So when people call our office, you know, they're working with me, they're working maybe with another attorney at our office, we help them draft their documents. But lots of times people say, I don't know if I want to work with an attorney. Maybe I want to try this on my own. That is completely fine. You're not required to have an attorney to have any of these documents, even a trust, even some of the more complicated documents. You're not required to have an attorney. But they're certainly helpful. So what I tell folks is, if you want to try to do this online or get a book at Barnes and Noble and do it on your own, it's okay. Go ahead and do something. It's better to start with something. Usually what I recommend is that someone, at least after they've drafted their own documents, send them to an attorney and have that attorney tell you what they mean. Because if I have this happen quite a bit, someone will prepare their documents online, they'll send them to me, and I will just tell them, I'll read through the documents, review them, tell them what's gonna happen with these documents, and if it's what the client wants, it's okay. We help them sign their documents and witness them, and that's fine. But maybe the client may need to change the language in the documents to freshen them up before they sign them, because maybe what they've actually put in this will isn't what they want. And so we just talk about it, but the goal is to help the clients get their documents in order and get their situation in order in any way that that is meant to happen. So you can do things online, you can do them on your own, but I do recommend you meet with an attorney or have someone review them with you. There's no requirement, but it's just best practice. In terms of where to keep your documents, this is something I get asked a lot, and I get a lot of funny answers from people about where they keep their documents. The best practice, in my opinion, is to have an attorney keep them at their office. New York State is a state that says if you lose your original will, so if I, Emily, have lost my original will and then I die, and then a copy cannot be sent to the court or probated because I lost it. And if nobody else knows what happened to it, the presumption in New York is that I revoked that will, that I tore it up or I put it in the fire and I didn't want it anymore. And so no one can send in a copy. But if I sent my will and my attorney has that will, then there's no presumption that I revoked it, because when I die, my attorney is gonna file that will with the court or give it to my family members. They don't hold it hostage. It's my will that they're gonna give up. And if I lost an original, or if I lost a will at home, if I would have had to reach out to my attorney to let them know if I wanted to update my will. And if the attorney doesn't have any notes that say, yeah, Emily reached out to me to update my will, then the attorney's assumption is that you wanted that will and that it's not revoked. So the rule of thumb is generally you want an attorney to hold your will, but there's other options. The other options are, number one, you can have your will filed with the court and you can have it filed there early. So Emily, I can sign my will today. It's a $45 filing fee, and I can send my will to the surrogate's court, the original, and I keep a copy, that they keep the original there. The only downside to doing that is if you put your will on file with the court, then if you sign a new will, you have to go unfile the old will and put the new will on file. The other thing that can happen if you have an old will on file, and let's say you signed a new will, but you didn't put it on file, so you got the old will at the court and you have your new will. Well, when I file that new will with the court after you die, any beneficiaries listed under your old will and your new will, we have to reach out to all of them, because that old will was on file with the court. And even if you disinherited some of the people in the old will, because you filed it with the court, they have the right to see it, and they'll see that they were now disinherited or that their numbers changed. So usually we don't want people to file with the court, but it is an option. Another option is you can keep your will in your safe deposit box. I don't really recommend that because those are notoriously difficult to get into. You can keep it in a fireproof safe at your home. You might want to give it to your executor to hold for you. I will just say that at our office, even if a client has done a will, but they didn't do it with our office, we offer to keep people's wills for free. So if somebody has a will and you just want us to keep it for safekeeping, we'll do that, and we'll give you a letter saying that your will is on file with our office. And you can have it back anytime you want it. We don't charge for that service. It's just a complimentary service. So we've talked about the 4 documents: a will. We want everyone to have a power of attorney, healthcare proxy, and a living will. And then talked about having maybe something for funeral wishes, an appointment of agent to control remains. Talked about maybe some people want trust agreements to help them in different circumstances. And where do you keep your documents? I know there was an attorney in town a while ago that used to tell people to keep their documents in the freezer. And I'm glad I know about that, because we will tell people, they'll say, I can't find my mom or dad's will. And we'll always say, well, look in the freezer, even though that's the last place people would look, but it is interesting. So if you're going to keep it somewhere like that, let somebody know where you're keeping it, because you don't want it to be a chore for someone to find out where your will is. Because you need access to that soon after someone passes away. If you're the executor under someone's will, it's a big job. It's a big job to be someone's executor. And if you've got a mom or a dad and they're saying, oh, I'm gonna get my will done, I would tell you to suggest to them, if it's gonna be you, it's much easier to be a trustee than it is to be an executor. So if someone were to ask me, Emily, I'm getting my estate planning documents done, what's the easiest thing for my kids? I'm gonna say it's easiest for your kids if you use a trust. Because you're doing some additional estate planning for them. You can do some additional estate planning for someone under a trust. And you're also gonna avoid the court process. I don't want to steer anyone away from a will, because you remember, you still need the will even if you use the trust. But it is sort of the best standard because it allows privacy for your family. That you get to be on your own timeline instead of the court's timeline, and you kind of get to do things your own way. The probate process, so after someone's will gets filed with the court, is a process that takes a minimum of 7 months in New York State. And that's 7 months from the date the executor is appointed. They have to report to the court for 7 months. And if they've done their job and the home is sold and all the money gets distributed to the beneficiaries in that time, then they can close the estate after the 7 months. They usually have to file a tax return and some other things, but it is a job. On our website, we have something called an executor's guide that can be very helpful. If anyone wants to go to the Bousquet Holstein website, we have an executor's guide there that tells you the timelines and when things need to be done. These documents, if you don't have any of them, it doesn't mean that your estate is all going to go to the government. That's something that I like to let people know. So if I die without a will, let's talk about what happens then. So I'm Emily Lawson Hatch. Remember, I'm married. I've got 2 minor children. They're under 18. So if I die in New York State with no will, the New York State statute says that my spouse gets part of my estate and my kids get part of my estate. So if you're a person married with a couple of kids, what happens is my spouse let's say there's $200,000. Let's pretend I got a $200,000 house. It's only in my name. My spouse gets the first $50,000 off the top. He's entitled to the first 50. And now we're down to 150. And then because a lot of people will think, oh, my spouse gets everything, but that's not the way it works in New York. So the 200,000, he gets the 50 off the top. And then we are down to 150. And what happens then with the rest is my spouse splits it with my kids. So my spouse gets 50% and my kids get the other 50% for them to split. So out of 150 left, my spouse gets 75 and my kids would have to split the other 75. But remember, they're minors, they're little kids. So not only is it a little complicated because my spouse has to split our money with our kids, but he also has to get appointed by the court to oversee their money. So my spouse is, you think, well, we're parents, you think we're the guardians of our children, but we're really sort of, and we're sort of not. You're not technically the guardian for your children unless the court has appointed you as guardian. Sometimes the court appoints someone as guardian for someone's person, making healthcare decisions for them and where they live. And sometimes you could appoint a guardian over their property. So in this case, if I've died, my spouse is going to get some money, but he's also going to get appointed as guardian over those kids' money. And he would oversee their money in their best interest until they're 18. And then they'd get the money at 18. So a lot of unintended things would happen if I died without a will, because none of that is what I want to have happen. So it's real important that you look at your life and you get an understanding of how your assets would pass if you died without a will and without a trust. And if that's okay with you, then that is okay. You don't have to have those documents. But if you want things differently, then you'd put it in writing. And I would say out of all these documents, really the most important in my mind is the power of attorney. That is a document that can sort of make or break people. If you're at the end of your life or if you've had something happen, this is where you're saying who your point person is going to be. And everybody needs a point person. For me, it's my spouse. And then it goes to my 80-year-old mother, who's still very spry and smart. And then it goes to siblings. But not everybody even has those folks in their life. And if you're the kind of person who doesn't have a lot of people, maybe you want to talk about how to find a point person. I'm always happy to talk to people. Every once in a while, if people really do not have family members and they don't have friends, maybe they've outlived everyone, sometimes people will appoint a professional as their point person, as their agent, or as their executor. And every once in a while, that's us at our office. Sometimes we get appointed to make people's financial decisions or healthcare decisions, that usually people appoint their closest family members or friends to those kinds of roles. But there's no right or wrong. It's whatever somebody wants. I want to tell you about on healthcare proxies. Since that's the kind of document where you can only appoint the one person at a time, if someone has a bunch of kids or they have a bunch of friends, sometimes we'll add an addendum or some language that says, even though I can only appoint one person at a time, I do ask my agent to consult with a group of people. I mean, you can name the group. I ask my agent to consult with my siblings before making any decisions. Still means your agent's in charge, but you ask them to communicate with people in your life. And that's sort of a nice way to include other people. When you get documents done, whether you prepare them or an attorney prepares them, the other part is keeping it safe in a place where the documents are safe, but making sure the right people have copies. So you might want your power of attorney to have a copy of that power of attorney. You might also want to share with them some information about your finances at that time. Maybe you're going to say, listen, Joe, I named you as power of attorney, so if something happens to me, you can pay my bills for me. Please and thank you. But also, here's just a bullet point list of where my assets are. You don't necessarily have to tell somebody what all the amounts are, but you can say, you know, I got my house, I've got an account at Empower, I've got an account at Chase Bank, I got a loan somewhere else, I've got my car. And you can just let them know what your universe is. So if they step into that role, they can take over. If you have pets, you want to make sure to let them know who your veterinarian is, where they can go if they need help. So there is some planning that goes in to that, to just let people know. And that's why if you're working with an attorney, it can be helpful because they can sort of be the point person, at least to help you get everything together. But I know there's a lot of online systems that are good at helping people with that too. A question I get asked about quite a bit is, where do I keep my passwords, my usernames and passwords? There's no perfect answer, but the goal is to keep them somewhere that your point person can find them. So, you know, my mom's method is to keep Post-it notes all around her computer with random usernames and passwords, and she's hoping that I'm going to figure out where they all go to. Please don't do that. It's better if you have, there's a couple options. So I know for me, I keep them in a Word document on my computer at my office that has, you know, security systems. And every 6 months, I print them out and I put them in an envelope in my estate planning file. And it says on the front, gift to my husband if I'm dead, or to my mom, so that they know where those usernames and passwords are and they can get to them. But the goal is for you is make sure there's some way someone can get to those in the future. There's really cool online programs now. There's apps that will keep all of your passwords. You have a main password that you use to get into it. And on those apps, you can say, who's your trusted contact? And if the app company is contacted by the person that you've named, they would also be able to have access to your usernames and passwords. And you can say in there that they would only get access if you're deceased or if you're incompetent. Those are wonderful ways to, maybe you don't feel comfortable sharing your passwords now, but you can share them for the future. So keeping track of your estate planning documents is really important. Your deeds, like, you know, the original deed to your house isn't very important. You get that directly from the county at any time. But where your estate planning documents are is really, really important, and what your wishes are. If you're going to prepare your own documents, something I usually encourage people to do is put right in your will or your trust, or in a separate, even in a letter with it, is say what your intent is. Because that's what people, when they're reading your documents, are trying to figure out, okay, you know, what did Emily want when she wrote these documents? And if I've written my own will, if I wasn't a lawyer, sometimes that can be unclear. And so it's okay in a separate statement of intent or write in your document to say, my intent in all of this is to leave things equally to my kids. Or my intent is to give a bunch of people, all my family and friends, the chance to say yes or no to any of the items in my home. And then everything's going to charity. But you get to say what your intentions were, what you want to have happen. Because most people in your world, they want your intentions to be fulfilled, right? We like to grant people's wishes, but we have to write those wishes down for people to know what they are. I want to let you know now that if anybody does have any questions, feel free to add them into the chat. I'm going to tell you a couple of things that I've learned over time. I'm hoping it'll be helpful to you. So one is, I get questions quite often about, if I want to work with an attorney, how do I pick someone? Or if I worked with an attorney a long time ago, how do I switch? Well, you can pick anyone you want to work with, and if that attorney is available, they're probably going to say, yeah, I'm happy to work with you. A big component is figuring out what the attorney's fees are. So every attorney is a little different. Sometimes people charge hourly. So at our office, we often charge hourly, or we'll charge a flat fee. It depends. It depends on the kind of work and the client and what we're trying to do. But you're usually looking, so you want to ask the attorney how much they charge, and what you're getting for what they charge, and are they going to keep your documents for you? If you worked with an attorney a long time ago, I'll have clients that say, you know, I worked with this guy a long time ago, and he's retired, or I don't want to go back to them. That's okay. You can sign an authorization at your new attorney's office, and you can authorize your new attorney to contact your old attorney to get your file. And then you don't have to even talk to them or worry about it. And we can get the old file. Sometimes files get lost and maybe your old file doesn't exist and you need to start new with somebody else. Whatever iteration it is, it's okay. Attorneys are used to clients transitioning between offices, and so there's no hard feelings. The last thing I sort of want to touch on is something I get asked about a lot, which is pets. People will say, you know, I've lived my life and I've got my animals, and this is what I really care about. So before I mentioned making sure if you have animals that you let your executor know who your veterinarian is. Sometimes people also want to make sure whoever gets their pet, that they have some money to offset the expenses. And a couple ways to do that. So maybe you've got the kind of pet that you adopted them, and in the adoption agreement has to go back to the whoever you adopted it from. That's okay. You just want to, again, let your executor know or let your attorney know so we have notes in our file. Because sometimes people will say, I leave any domesticated animals I own to my executor. I ask my executor to rehome such animals, and whoever the new custodians are, I give them, you know, $500 to offset the expenses. Sometimes you're saying 5,000 or 50,000. You can say any number you want, that person would get that money and you'd hope to use it to offset the expenses. Sometimes the number is great. If you're giving someone $50,000, usually you're setting up a trust, and in your will, you're saying, okay, maybe it's because you have an animal that lives a long time. Maybe you have a tortoise or a horse or a parrot, something like that. And so you're saying, I'm going to leave X amount of dollars and it's going to be held in trust. And then maybe you put someone who's going to be the trustee of that money, and they dole out the money over time to the things the animal needs. They can give them to the custodian or the guardian. But that's usually how people approach animals. But that's a real important component of a lot of people's estate planning. And so I don't want to bypass that. The other thing, when I talked about trust and avoiding the court process, I want to talk about how to do that a little bit. So if you don't have a trust, it's okay. You can avoid court on your assets by making sure you've got a beneficiary on there. So you can use a deed for your real estate. You can do a life estate deed or the transfer and death deed that we talked about before, or just have a joint owner on there. So that's for real estate. For bank accounts, to ensure that your bank accounts don't go through the court process, you can add a joint account holder to your bank accounts. But if you add a joint account holder, you can't take them off without their permission. So you really want to think about that. The other option is to add a beneficiary right on your bank account. And you can do that. You can go over to Empower Credit Union and say, I want to add a beneficiary to my account. And I can do that. And I don't have to check with the beneficiary first. Usually you need the person's name, address, phone number, sometimes their social security number and date of birth. So you might have to reach out to them for that. But if you name a beneficiary on your bank account, then when you pass away, any person can send a death certificate to that bank account. And then it's usually 30 days after you passed away, that bank will give those monies to whoever's listed as the beneficiary. So it can get a little complicated with estate planning, but and most of that is because I'm giving this advice right now, but everyone's situation is so unique, and everyone's situation is different. So that's why it's nice to work with an attorney, because we can say, oh, you've got these assets. Let me give you some advice about what you want to do. When I have people that come in that have multiple children, I will caution people away sometimes from naming one kid as the beneficiary of everything. Sometimes they'll say, okay, I got this kid, Paul. He's so great. I'm gonna name him as beneficiary of everything and just leave it up to Paul to distribute money out to the other siblings. It's okay to do that, but I would suggest writing down your intent that says, yes, I'm naming Paul, but it's not my intent that he keeps all the money. It's not my intent that he lords it over his siblings. My intent is that he's generous with his siblings and that, you know, depending on the circumstances, that he ultimately do his best to divide it 3 ways and distribute it that way. Again, putting your wishes in writing is the most important factor. I'm gonna wrap up for now. So Sam, if you want to jump in, but I'm happy.
You know, speaking of that, Emily, about, you know, naming your children and everything, how about when you feel like you've given to them over their lifetime and you don't plan on, you know, having them get anything necessarily after you pass away? Is it important to make sure we still include them in our will and make that specific?
That's a great question. So in New York State, you cannot disinherit a spouse. You can disinherit a spouse up to 2/3 of your estate, but you have to leave them at least 1/3 unless they sign off. But with children, children do not have an automatic right to inheritance in New York. So if you've given your kids money during life, you do not, number one, even if you haven't done that, you're not required to leave your estate to your children. But the best practices is if you have a will and you're not leaving assets to your children, you still need to state that you're not doing that, because otherwise your kids can later claim that it was a mistake and you didn't know what you're doing. So if I'm Emily and I've got my 2 kids and I'm like, no, I already gave them a lot, I'm gonna give my money to a niece or I'm gonna give it to charity or someone else, I would say, this is Emily's last will. I have 2 children and I would need to say, I intentionally am not providing for my children under my will for personal reasons known to me. I don't have to say anything else. But I just have to acknowledge that those are my kids and I'm not gonna leave the money to them. I'm gonna leave it to somebody else instead. But people absolutely allowed to do that.
Yeah, right, right. That's good.
Yeah.
And you know, speaking of children too, Emily, with the minor children, and you're saying, so we, you know, you hear questions about, you know, you know, I'm divorced from my spouse, we share minor children. When I say, if I do sadly pass away, I don't want, you know, he or she to get the children or whatnot. I want my mother to, you know, have the guardianship rights and stuff. You know, so what do we want to add in the will? How enforceable is that? Does, like, you know, family court get intertwined with those situations? Yeah, how does that play out sometimes?
If I'm Emily and I've got an honorary ex-spouse that I'm real worried that he's gonna get the kids, because under my will, I can name whatever guardian I want, but I'm not, whoever I name as guardian isn't gonna take away that ex-partner's parental rights. So if I've got my mean ex-spouse out there, they would be the de facto guardian, but in my will, I don't have to leave the money to that person. So if I've got my kids and I've got that jerk ex-spouse, I might say, I leave my money and trust for my children, but I'm gonna name who the trustee is. I don't want that person overseeing it, so I'm gonna name my sister or name my friend or name someone else. I can also say, when we put this language in, although my children have another parent out there, I ask the court to look at this situation closely because the other parent would not be an appropriate place for my children to live. And you can ask the court to look at it and you can ask the court to appoint someone else's guardian. The court, and then it does become a family court matter, but you definitely want to put that in. Maybe you're saying, because the court's going to look at what's in the best interests of the children. And you don't want to rake someone under the coals in your will, because again, this is a public document that you can say there are substance abuse issues here. There's violence in the home. Like, you want to let the court know why you're saying that this person's not just because they're a jerk, it's because there's other things going on, and you can put that in your document as to why, and the court will look at it very closely and they'll get involved.
Oh, that's a good point. Yeah. Okay.
Great
Yeah.
questions.
Thank you. The last one I think I wanted to just touch base on is that you had mentioned about wills and the importance is 2 witnesses, you know, at the end of the document and things. How about those other, you know, especially the main 4? How about the powers of attorney, living wills, healthcare proxies? How do we want to make sure, you know, you stated intent, but what else, you know, in terms of like signatures and witnesses for those big documents, do we want to make sure they're completed correctly?
So your will is required to be witnessed. Your power of attorney is required to be witnessed and notarized. Your healthcare proxy is required to be witnessed, and your living wills needs to be notarized. So you need witnesses and a notary for all of this. And I'll tell you, most of the times banks won't be a witness or a notary for these documents.
Oh,
Some
interesting.
will
Yeah.
be the power of attorney, But most banks have policies where they'll say, we don't want to be a witness on someone's will, because if we get called into court, now our tellers or the people here are going to be called in as witnesses.
Mhm.
I'm not saying they all won't, but most of them won't. So you got to find someone, a friend or someone who's going to be a witness or a notary for you. And remember, the key is you want to make sure you're naming the witnesses and the notary aren't mentioned in your documents.
Right.
You need to be other people.
Right. And for those documents for those attending, they don't need to be, you don't have to you don't need the original other than the will, right? Like if you have multiple copies of your power of attorney, healthcare proxy, living will, right?
Yeah.
Those can be shared.
Yeah, all those documents can be shared, and oftentimes people are coming in and they'll say, I don't want my kids or any of my family members to get a copy of my will, but will you send them all a copy of my power of attorney and my healthcare proxy? We don't charge for copies, so we're often sending out copies to all kinds of people. So the original will is super important. Even though a power of attorney, though, you can use copies of it. Every once in a while, we'll have a stickler financial institution that wants to see that original or a certified copy. So I
Yes,
usually tell people that power of attorney, the original, if you can keep it in an attorney's office, that's a nice thing, because then we can make certified copies for you.
Mhm.
But just all these documents are really important. You want to be real mindful about where you keep them and who knows where they are.
Right, right. Yeah, do you tend to, I would imagine, make sure for the power of attorney, maybe sharing it with your regular financial institution, right? And then, yeah, right. And then your healthcare proxy, I imagine your, regular, yeah, doctor and things like that would be helpful to share those things, right?
Yes, when we send people their copies, we usually make them extra copies of their healthcare proxy, or we're just mailing them out to their kids. And then they can put a copy on file with whatever hospital they go to. If they tell us the hospital, we'll send it over to St. Joe's or Kraus for them, and they'll put it on file for them.
Right. Great. Yeah, well, I learned a lot of information. I could keep going with questions, but we are getting to the final minute. So I do really appreciate your time, Emily. Everybody who's here in attendance, remember, we'll get this on our website pretty promptly, probably by this afternoon. You can check it out if you had to miss a portion or somebody who wanted to attend who couldn't. So thank you so much for attending, and thank you to Emily for sharing such valuable information. We really appreciate your time.
You're welcome. Thank you.